Once you go to contract, these are the essential elements of the contract. You leave the parties and the sellers, the buyer and seller, the description of the property. At this point, you want the legal description of the property, because now you're contracting for serious. You're going for real here. So you want to make sure that you have the entire property under contract. Otherwise, people like this guy here, when we first put it under contract, he was trying to exclude the garage. You gotta be kidding me. $25 million bucks. The guy wants to keep the garage. All right, financing provisions. If you're going to do some seller financing or the terms of which you're doing your financing, this is the time where you'll include it. Title, evidence, and examination. You want to make sure this dude actually owns the property. This will be the time where you want to make sure that they've got clear title, similar to residential properties. You'll have your closing date and closing procedures, which typically include your attorney's going to go back and forth, go to the title company, right? You'll have the allocation of cost and fees. Who's paying for closing costs? You know it costs money to close, especially when you go to a title company. So you will disclose those fees. It's going to do what? You'll have your escrow agreement, which will basically describe, when you go to the closing table, how the title company is to proceed with the funds. Default and return deposit. These are the terms that protect you if you're putting the deposit down, and it protects the seller. Because if you go in and you walk away for no good reason, they can keep that deposit, by the way. They can probably even sue you for more, technically. On the other side, if you actually have the property in a contract and you make a deposit, and for a legitimate reason that was within the contingencies, you have to bail, and they don't give your money back, you can sue them and their attorney or escrow agent for damages. So you get your money and you can probably get some more. So typically, by doing that and working with third parties, you will get your money back. That's the point. Does that make sense? If there's any brokers involved, you will disclose it and what fees they'll get and all that good stuff is here. The acceptance period, again, you can have a 30-day period with an opportunity to expand or whatever you're going to do to extend the date. Miscellaneous provisions and contingencies. Keep in mind, those provisions and contingencies are the ones that will protect you or will give you an opportunity to have a true, solid due diligence period. I typically say that the due diligence period does not begin until the seller provides all of the information that we need to do our due diligence. Why? Because they can start from the day you sign the contract. But the date that you receive the due diligence information might be 2 days before you're supposed to close. That's not going to fly with me. If I don't get it within a certain date, I'll send them an actual official letter, or our partners will submit a letter and say, we're going to freeze the dates because you haven't provided us with the information we need in order to close. You don't let somebody strong arm you.